In the matter regarding policy strategy for grant of bail, which Supreme Court took suo motu, it concluded that where there is a policy of the appropriate government laying down guidelines for consideration of the grant of premature release under Section 432 of CRPC or Section 473 of BNSS, it is the obligation of the appropriate government to consider cases of all convicts for grant of premature release as and when they become eligible for consideration in terms of the policy. In such a case, it is not necessary for the convict or his relatives to make a specific application for grant of permanent remission. When the jail manual or any other departmental instruction issued by the appropriate government contains such policy guidelines, the aforesaid direction will apply. The Supreme Court directed states and union territories that do not have a policy dealing with the grant of remission in terms of Section 432 of CRPC or Section 473 of BNSS to formulate a policy within 2 months from today. Appropriate government has the power to incorporate suitable conditions in an order granting permanent remission. Consideration of various factors which are mentioned in paragraph 13 by way of illustration is necessary before finalizing the conditions. The paragraph 13 states that the conditions cannot be vague and should be capable of being performed. The conditions must aim at ensuring that the criminal tendencies, if any, of the convict remain in check and that the convict rehabilitates himself in the society. The conditions should not be so oppressive or stringent that the convict is not able to take advantage of the order granting permanent remission. The conditions cannot be vague and should be capable of being performed. Order granting or refusing the relief of permanent remission must contain brief reasons. The order containing reasons should be immediately communicated to the convict through the office of the concerned prison. The copies thereof should be forwarded to the secretaries of the concerned district legal service authority. It is the duty of the prison authorities to inform the convict that he has the right to challenge the order of the rejection of the prayer of the grant of remission. Referring to the matter of Mafabai Motibhai Sagar, Supreme Court stated that an order granting permanent remission cannot be withdrawn or cancelled without giving an opportunity of being heard to the convict. An order of cancellation of permanent remission must contain brief reason. The District Legal Service Authority shall endeavour to implement NALSA's SOP in its true letter and spirit. The District Legal Services Authorities shall also monitor implementation of conclusion A as recorded, which states that where there is a policy, then it is obligatory for state government to consider premature release for all convicts, even without application by relatives. For this purpose, the District Legal Service Authority shall maintain the relevant date of the convicts and as and when they become eligible to a consideration for grant of premature release, they shall do the needful in terms of this conclusion. The State Legal Service Authority shall endeavour to create a portal on which the data can be uploaded on real-time basis. In the cases of Sangeet and of Mohinder Singh, the Supreme Court did not consider a scenario where a policy was framed by the appropriate government for grant of premature release or grant of remission. The court considered this factual contingency in the case of Rashidul Jafar versus State of Uttar Pradesh. The policy has been amended to remove the requirement of convicts submitting an application for premature release and instead places the responsibility on the officers of the state to consider eligible prisoners. The Prison Administration Legal Service Authority at the district and state level and the officers of the police department and the state must diligently ensure that cases of eligible prisoners are considered on the basis of policy parameters. We have gained a distinct impression based on the cases of Supreme of which have come before our Supreme Court here and even earlier that there is a general apathy towards ensuring that the rights which have been made available to the convicts who have served out their sentences in terms of the policy are realized. This results in the deprivation of liberty of all those who are entitled to be released. They languish in overcrowded jails. Their poverty, illiteracy, and disabilities occasioned by long years of incarceration are compounded by the absence of supportive social and legal structures. The promise of equality in a constitution would not be fulfilled if liberty were to be conditional on an individual's resources, which unfortunately many of these cases provide hard evidence of. This situation must change, and hence this court has had to step in. If such a policy of release exists, and if the state government or the government of union territory raises a contention that relief will be granted only to those who apply as per policy, it will amount to saying that even if convicts are eligible for consideration in terms of the policies, their cases will not be considered in terms of the policy. Such conduct on the part of the states will be discriminatory and arbitrary and amount to violation of Article 14 of the Constitution. The power under Section 432(1) must be exercised in a fair and reasonable manner. Therefore, whenever there is a policy for consideration of cases for permanent remission, it becomes an obligation of the state to consider cases of every eligible convict under the policy. The court also observed that power under Section 430 of CRPC is circumscribed by Section 433A. It provides that where a sentence of imprisonment for life is imposed on a conviction of a person for an offence for which death is one of the punishments provided, or where a sentence of death imposed on a person has been commuted under Section 433 into one of imprisonment for life, the appropriate government cannot grant remission unless the convict has served at least 14 years of actual imprisonment. There is an identical provision in Section 475 of BNSS. This is an embargo on the power of the appropriate government under Section 432 of CRPC. The court said that we may note that the power of the President of India under Article 72 of the Constitution of India and the power of the Governor under Article 161 of the Constitution to grant pardon, commute sentence, or remit the sentence remains unaffected by Section 433A of the Criminal Procedure Code or Section 475 of the BNSS.